Hi, this is Huang Lei, CFP, EA, and real estate professional in California. This video covers the second situation. The spouse who died had a will, but no living trust. Many families think a will avoids probate, but in California, a will usually guides the probate process rather than replacing it. That point is critical. A will names beneficiaries and often names an executor, but if the estate includes probate assets above California's simplified transfer limits, the surviving spouse may still need a court-supervised probate administration. So what should the surviving spouse do? First, secure the original signed will and the certified death certificates. The original will should be protected carefully because the probate court generally wants the original document, not just a photocopy. California courts explain that the will usually must be lodged with the court after death, even before the full probate process moves forward. Second, identify who was nominated as executor. If the will names the surviving spouse, that person will usually petition the court to be formally appointed as executor. If someone else was named, the spouse still needs to understand how that affects control over property, notices, and administration. Third, the surviving spouse should make a complete asset list, just as in the no-will situation. That includes real estate, checking and savings accounts, investment accounts, retirement plans, life insurance, personal property, and business interests. It is important to separate what passes by beneficiary designation or survivorship from what actually passes under the will. Once appointed, the executor has real duties. Those typically include collecting assets, obtaining appraisals or date-of-death values, notifying heirs and beneficiaries, paying valid debts and expenses, filing required tax returns, and distributing the remaining estate according to the will. The will does not automatically override California spousal property rights. The surviving spouse still owns their half of the community property, and California law also protects certain spouses who were unintentionally omitted from a will. In some cases, an omitted spouse may receive a share similar to what that person would have received if there had been no will at all. Real estate title should also be reviewed immediately. If the family home or rental property was titled with survivorship language, the surviving spouse may be able to clear title through recording procedures. If the real estate was in the deceased spouse's name alone, the surviving spouse generally needs probate authority before selling or transferring it. Tax planning still matters here. The executor and surviving spouse should document date-of-death values, confirm how basis adjustments apply, and determine whether the estate needs fiduciary income tax filings or other post-death returns. This is especially important when the estate includes appreciated real estate, concentrated stock positions, or business interests. A will helps, but it does not usually eliminate the surviving spouse's workload. The spouse still needs to secure the original will, petition the court if required, identify which assets bypass probate, protect community property rights, and coordinate legal and tax administration carefully. If you want more videos on how taxes, investments, real estate, and estate planning all fit together, hit like, subscribe, and drop a comment.